Hi everyone, welcome back. We're going to be speaking today about the history of the Ottoman Empire and specifically how the Ottoman Empire changed and transformed its system of law, and specifically that part of law called Islamic law, which is basically the majority of law in that time. And we covered the basics of Islamic law in the previous class, but now we're going to go into the discussion of, well, what is it that the Ottomans did to transform the system? Because Islamic law has been around for a long time, since it kind of was developed around the year 800. It continued until 1900 and continues today in some contexts. But the basic question is, well, what is it that, the system didn't stay the same? It keeps changing and developing. And there's changes that the Ottomans introduced to the system that we're going to go over today. So if you remember, as we pointed out, there's actually a few different types of law at work in early modern Islamic societies. The most important one is what we would call Sharia. This means the way. This is law created by jurists who are independent of the state, right? They're coming up, dealing with new legal questions, putting out opinions, creating books on legal methods, etc. And this covers everything, that is all interactions between humans, but also interactions between humans and God. So everything from the way you pray to what you're supposed to eat to also obligations, questions about prosecuting murder, etc. like that. All that stuff, commercial transactions, comes under the Sharia. Now, there's another law created called the Qanun, this is law decreed by the Sultan. This is much more limited. It has a smaller place in the space of law. It's basically there to deal with administrative matters. How is the government going to be organized? Who gets promotions and when? But also questions of like maintaining order in general. Sometimes the Sharia is not very good at responding quickly. So, for example, when you need to stop bandits murdering people on the road, it's difficult to find witnesses, to prosecute them, to drag them to court, etc. In that case, the leader, the sultan, or the political leader, can actually take the prerogative and basically attack bandits or put them down, kill them, without necessarily going through the Sharia to do so. But in most of these cases, it's a very limited amount of material that goes into Qanun. Okay, so these two come together and work together to create, in general, the general space of law. Most of what's out there is under Sharia, but a bit of it is under Qanun. The Qanun can be changed by the ruler, but the Sharia technically is independent from the ruler. Now keep this in mind because this is going to be important in the next few slides. Finally, there's also what we would call customary law, just the way things are done in a locality. And sometimes, again, this is never written down, but it just applies in general. Sometimes it was just easier to keep things the way they were, especially, for example, in tax regimes, things like that. Now, another bit of background. Remember, there's two essential roles in Islamic law positions. One is the Qadi, or the judge, sometimes called the magistrate. He's going to be making specific rulings on each case. Okay, so he's going to take a case which is brought up by a plaintiff and then basically look at the law and institute his judgment on it. Now that judgment doesn't create precedents, it just is one specific case, a ruling on one specific case, and it just applies to that case. To create larger ideas about how politics law changes, you have to turn to the jurists or the muftis. These are people who are going to make legal opinions. They studied legal sources, they think about the legal question, and when posed with a new controversy, a new legal situation that hadn't occurred before, they're going to issue an opinion on it. Now, the interesting thing is that muftis are not part of the government. The Qadi is. The Qadi is appointed by the Sultan or whoever's in charge of the state. The mufti, however, is not part of that world. He's independent, and in fact, there's no reason why one mufti is valued over another. It's ultimately up to the reputation that the mufti builds for himself that gets his ideas taken more seriously. And so this is essentially an independent jurist. Okay, that's the traditional system of Islamic law. Now, some of the things that the Ottomans did is institutional. They basically created a stronger structure for the application of Islamic law in general. Now, how did they do that? One, they created madrasas, places where they could train people who were knowledgeable in Islamic law, and they also created, as we'll see, courts, formalized the court structure so that it became a space of public records. Why did they do this? Well, because they were interested in the 16th century, in the 1500s, in response to the challenge from the Safavids, they had taken, and other changes, they had taken on this new identity as specifically Sunni Hanafi Muslims. That was the imperial religious identity of the empire. And part of that world is emphasizing the capacity to enact justice through the law. And so they built up a world in which different aspects of Sunni Hanafi Islamic religiosity was emphasized, right? And this is emphasized in their sponsorship of the Hajj, the way they controlled the Hajj, also the fact that they insisted that every town has a mosque, which was actually uncommon in the Islamic world at that time. But they also, for example, created courts. They turned the courts into spaces of public record and of public justice. Okay, and those court records, basically since the 1550s, continue to survive to today. They're still actually preserved, and they become a major source for us today. They're used by basically everyone in the Ottoman Empire, both Muslims and non-Muslims. You can see an example of one page of this on the right. And people record all sorts of events in it. We have, for example, this is from some of the oldest court registers we have. We have material like this, in this case, stories of sexual assault being prosecuted. It says, the married peasant woman, Can Pasha, accuses one Hamza of entering her house at night, climbing her bed and assaulting her. Hamza denies this, whereupon investigation of the people among the people of the village shows that he has been similarly accused with regard to another woman in the village, and therefore he has tuhmet, he has an accusation, set accusation against him. So Hamza is sentenced to punishment by the judge. Okay, so here we have a kind of aspect of public order developed. One of the things to remember is that there is no prosecutor in the system. The prosecutor is not present. Instead, people have to bring cases against other people. In this case, the woman, Can Pasha, accused another villager, Hamza. Similarly, we have in this case, Mezid brings a case against Husnia, wife of Shehi, saying that when he was staying at their house, Husnia came to him in bed after Shehi had fallen asleep. Husnia's character is investigated. 3 men of the neighborhood testify. We've never known any ill conduct on her part, and we cannot say she is prone to bad behavior. Right, so in this case, there was an accusation of rape by a man against a woman. The woman's character was investigated. There was no witnesses to this. So in this case, the character was revealed to be okay, and then they basically had to drop the case. But these are the types of things that are recorded, but also things like orders, deed of sales, all sorts of legal settlements. Everything gets put down in these registers. And so they actually form an amazing source today to learn about the people of the past. What happens when local courts aren't good enough? Say, for example, someone doesn't like the ruling that the local court in Aintab or in Bursa or Sarajevo liked. Well, then they could go appeal it. But the appeal court was at the divan of the palace, which you can see here on the right under the window where the Sultan may or may not be looking out over it. They could show up they'd have to travel to Istanbul, present their case to the kind of chief magistrates and the viziers, and then they would have a ruling on this. Sometimes in Istanbul, if you lived in Istanbul, it'd be obviously much easier to appeal cases. And often they dealt with, for example, trade cases. This is in this one. This is a appeals court case about guild privileges, basically market coercion. So in 1775, the sellers of new shoes took the sellers of old shoes to the imperial court, accusing them of buying new shoes from the cobblers and selling them among their wares, contrary to the established custom, right? So they have a custom, they're breaking it, and they're saying, well, you guys broke our agreement. nothing directly about law here that is an Islamic law, but they had an agreement. And this all goes back to guild works. These people are parts of different guilds. Each guild has its own corner of the market and cannot break it. The new shoe sellers also claimed, against the basic rules of supply and demand, that the practice of the old shoe sellers caused a shortage of shoes and increase in prices. In defending themselves, the old shoe sellers indicated that, in fact, the new shoe sellers intruded into their line of business by selling old shoes along new ones. So the Divan referred this case to the Qadi of the District Court of Istanbul. The Qadi made the parties agree henceforth they would never again intrude into the other's businesses. So what you have here is basically a form of commercial arbitration over a commercial dispute. They brought it to the Divan through their guild membership leadership. This was eventually sent back to the lower courts where they arbitrated an agreement and then settled it. Okay, so you can see all these different aspects of life which are being mediated through law, specifically Islamic law. Now we might think, who could you actually use these courts? I mean, these are Islamic courts, but they were actually open to everyone and anyone. This doesn't mean, though, that women, non-Muslims, and slaves were actively treated equally, right? So anyone could use it. And in fact, many non-Muslims or slaves or women did use it, but that meant that the ideal legal subject, the person who, was imagined to be of the highest regard, was a free Muslim male. Okay, so what did that actually mean? Is that it does in terms of testimony, the testimony of a woman or a slave or a child was worth, or a non-Muslim was worth less than that of a free Muslim adult male. Okay, so like if a woman gave one testimony and just one man gave another testimony, that man's testimony was worth one and the woman's was worth 1/2, and therefore his word was taken over hers, whereas 2 women would equal 1 man, etc. There's other sort of weird kinks in this system. So even though everyone could present it, it's interesting that there's odd aberrations in the court records. So for example, Muslims, Christians, and Jews often have the same name because they share the same Abrahamic patrimony. So Joseph, the word Joseph in Arabic or in Turkish is Yusuf, and many people were called Yusuf, but they would often spell Yusuf in a different way in the court records. So basically using a different letter that would spell it in a different way, even though it would be pronounced the same. So it shows that there's kind of an inherent inequality in the system, even though everyone was using it. But of course, this is not a society in which people expected equality. They understood that there was already inequality in the society, and they tried to function the best that they could. And in fact, most people, even though, let's say, the courts were open to everyone, people knew that, if you cheated on a certain way, if you brought a case against your employer, you did this sort of thing. And most often the cases, the solution would already be known. If you murdered someone and a case was brought against you, you knew that what would happen probably to you if there was enough witnesses, etc. So it was often in the interests of plaintiffs to basically settle or come to an agreement before the court, or they would only basically take to their court cases to court when it was unclear who was going to win, in some ways similar to our legal system today. And so there's often lots of different types of agreements that occur before anything actually comes to a court case. Now, that are some of the institutional changes that occurred in the Ottoman case, which is, again, the development of a court system which was already there before. There were already courts in Islamic law, but the Ottomans kind of solidified it, expanded it, turned the court records into a sort of public record rather than the judge's individual notes. And they basically developed this further and further as a space of public order. But they also started changing Islamic law structurally. Now, what they ended up doing is essentially starting to intervene in the very nature of the independence of jurists. Now, let's go back and remember that at this point, before the Ottomans, jurists are independent, right? The government's not supposed to control them or tell them what to do. And so they create law independent of the state, and then the state is tasked with kind of enforcing it. More importantly, there's kind of different law schools, as we went over. All of them are supposed to be equal. And in fact, in the Mamluk case, they would appoint judges from each of those. But let's look at what the Ottomans did. First and foremost, they created an official law school of the empire, which was Hanafism, right? So they took on a Hanafi identity. This is fine. There was usually a central school associated with the dynasty, but in this case, they turned Hanafism as the one and only school available to the top judges. More importantly, though, they created a formal hierarchy of jurists. In fact, they created an entire order of people in what's called the ilmiya, the learned hierarchy. So that includes professors, judges, jurists, etc. At the very top of this, basically, you could start as a student. You got a sort of waiting period, candidateship, and then you could go become a professor, go up the ranks. And if you were successful, then you could then transfer to the high level of judgeships, and then eventually possibly become, at the very top, the Mufti of Istanbul, which was the top post, the so-called Shaykhul Islam, or chief jurist, as we'll see in a second. Now, throughout this, there's different places where people could opt out. They could become local judges, they could become just independent muftis, etc. But there's essentially a hierarchy now. What they ended up doing is saying that, well, there's certain people in this world of Islamic legal scholarship whose opinion counts more, whose opinion should be given more legal weight. And in fact, the fatwas, or legal opinions, of the Shaykhul Islams, of the chief mufti, were compiled and formed a form of published legal law in some ways. And so this actually was a way of intervening directly in the formation of Islamic law. So the government didn't say, okay, you had to come up with this opinion or not, but they actually created positions of formal state muftis whose opinion were given more weight, and therefore allowed them to slowly intervene in the structure of Islamic law in a way that hadn't been done before. But then this also leads to the question, what about those scholars who issued legal opinions but weren't officially appointed? They weren't part of the government. How did they interact in this world? Well, one of the things that they did is they continued to write opinions, but they often had to turn to public opinion, to spreading their message in different ways to get their ideas out. And in fact, they maybe would be pressing the Shaykhul Islam to enact many of these ideas or their forms of legal opinions. As I mentioned, in this new hierarchy, there's a new post, and that is the post of Shaykhul Islam. The Shaykhul Islam, it traditionally was just a title, meaning someone who's very well respected as a scholar, but now they turned it into an official position who had control over the entire legal and religious hierarchy of the empire. The most famous person here is a figure named Abu Saud. He reigned during the period of Sultan Suleiman. And he spent, under his long reign, this is when he was born, but he actually basically created this institution and spent a lot of time basically reconciling the Sharia with the Qanun. Now, what does that mean? It means that when the Ottomans came to power in the 1300s and 1400s, they basically enacted a bunch of laws according to what they wanted, that was expedient for the ends of their government. But now that they took on this new legal identity as kind of a Sunni Muslim entity whose legitimacy was founded in enacting Sharia, enacting law, they realized, well, there's some things that we have to reconcile, especially taxation regimes and other things that just don't make any sense. And so he was actually part and process of that change. So he was also one of these reasons, because he was such a systematic transformer of Islamic law and reconciling these two worlds. It gave this new image of Sultan Suleiman as a dispenser of justice. But with that